Have you ever imagined being sued for a 1 million-peso debt on a credit card you never applied for? What would you do if this nightmare became your reality? Stay tuned to find out. This is the first case involving credit cards issued by Bank of Philippine Islands, BPI. Let this be an eye-opener and be a lesson for us public consumer. Follow if you find it interesting to receive more content like this. This is the case decided by the Philippine Supreme Court, entitled Bank of the Philippine Islands versus Spouses, Ram M. Sarda and Jane Doe Sarda, GR number 2399092, June 26, 2019. In a surprising turn of events, a case made its way to the Philippine Supreme Court involving the Bank of the Philippine Islands, BPI, and the spouses, Ram M. Sarda and Jane Doe. Sarda, BPI, a prominent banking institution, issued a credit card without the application or consent of Mr. Sarda. Over time, purchases and charges accumulated, resulting in an outstanding debt of 1,214,14619. The conflict began when BPI demanded payment for the credit card transactions, which Mr. Sarda denied ever making or authorizing. He claimed he never received the credit card, nor did he consent to its issuance. This dispute escalated, leading to legal battles across different courts. The regional trial court initially sided with BPI, ordering the Sarda spouses to pay the accumulated amount plus interest and other charges. However, the Sardas did not back down, leading to an appeal in the Court of Appeals, which reversed the decision, absolving them of the charges due to insufficient evidence of their consent or use of the credit card. Undeterred, BPI took the case to the Supreme Court, questioning whether Mr. Sarda should be held liable for the credit card issued in his name without his application or consent and for the transactions made with it. The Supreme Court, in its wisdom, denied BPI's petition, affirming the Court of Appeals' decision. The court highlighted the lack of evidence that Mr. Sarda received the credit card or authorized its issuance and use. It emphasized the bank's failure to exercise due diligence in issuing the credit card and the importance of consumer protection in the credit card industry. Dispositive portion, the petition is denied. The April 27, 2018. Decision of the Court of Appeals in CAGR CV number 106788 is hereby affirmed by Important doctrines discussed. Preponderance of evidence. In civil cases, the burden of proof lies with the party asserting a claim. The party must establish its case by a preponderance of evidence, considering all relevant facts and circumstances. Issuance and use of credit cards. The decision reiterates the principle that the issuance and use of credit cards must be accompanied by clear and explicit consent from the cardholder. Without such consent, the cardholder cannot be held liable for transactions made using the card. Duty of diligence by banks. Banks have a duty to exercise a high degree of diligence in their dealings, especially in the issuance of credit cards. This includes ensuring that the cardholder has indeed authorized the issuance and use of the card and is aware of the transactions charged to it. Protection of consumers. The case underscores the importance of protecting consumers from unjust claims and the responsibility of financial institutions to adhere to established legal standards and procedures in the issuance and management of credit cards. This case serves as a crucial reminder of the importance of vigilance and responsibility in managing financial instruments like credit cards. It underscores the need for banks and financial institutions to uphold high standards of diligence and transparency, ensuring that such instruments are only issued with clear consent and understanding from the consumers. This story is based on factual events as reported in a Supreme Court decision. It is simplified for general understanding and should not be considered infallible or be used as legal advice. Viewers are encouraged to consult professionals for advice on similar issues.